Hello, everyone. Welcome. This is Carla. I hope you can hear and see me well. So sorry, we had a bit of a technical difficulty admitting participants in. Hopefully that's all sorted. I hope you also see my screen. So welcome. We are from the Center for Art Law under Judith Bressler Fellow, and I'm excited to welcome you all today to our Art and Copyright Law Clinic. Before I hand it over to Billy, our speaker for the night, I would like to just take a few minutes to tell you a little bit more about the center and the work that we do. So the Center for Art Law is a Brooklyn-based research and education nonprofit. We are dedicated to offering resources and programming to advance the arts and legal communities. Through our website, newsletter, and events, we disseminate information and update our audience on all things art law. So we have news, programs, cases, publications, and a lot more. The center also facilitates conversations and learning opportunities such as this one, but also workshops, webinars, and even our first summer school, which is happening this week. We invite you to subscribe to learn more about our offerings and catch up on everything art law. If you really enjoy our work, you may also consider becoming a premium member. Memberships are discounted for artists and students. It will allow you to access our case law database, past event recordings, and discounted tickets to our events, among many other benefits. And speaking of our events, we would like to share a few of the offerings we are having for this coming month. Tomorrow, if you're interested in anti-money laundering and the art market, we are having a CLE program taking place at 2:30 p.m. In-person tickets are sold out, but we still have some seats for the online attendance modality. So please take a look at our website to learn more on how you can purchase a ticket. We are also having a few June is also filled with legacy and estate planning events. So we have an event, we will have two workshops, one on artist estates and those who are looking to explore it. So legal considerations for both heirs and third parties. We also have a very interesting program coming up on catalog raisonnés and a clinic such as this one where you'll be able to consult with an attorney, but also appraisers and tax advisors on legacy and estate planning issues. And for the lawyers in the room, on June 24th, we will be having our bootcamp, which is a CLE program aimed at training legal professionals to work with visual artists and other art market participants. This edition will be on artist-dealer relationships. It will happen in New York in person, and we encourage everyone who may be around to attend. And to learn more about these and other offerings, make sure to visit our website, subscribe to our newsletter, and follow us on social media. This is it for the center's introduction. Before I hand it over to Billy, just a few housekeeping items. The introductory remarks are being recorded. You will receive a link to it after the session. Consultations will take place in private breakout rooms, and those are confidential. We will be sharing in the chat a handout with a few extra resources for those who may be interested in learning more. You are welcome to put your questions in the chat box during the presentation. They will be addressed, hopefully, as they come. Also, feel free to keep your cameras open, but do keep your mics closed. Sorry, there's a bit of background noise. So without further ado, let me introduce you to Billy Trabaudo. He's a partner at Bardacke, Allison Miller, LLP. Billy, thank you so much for being here with us today. We are very excited to have you. And for the sake of time, I won't be reading his full bio, but you will be able to find it in the handout that will be shared in the chat. So without further ado, I hand it over to you, Billy. Thank you so much.
Great. Thank you so much, Carla, and thank you all for being here. I'll just give you a little bit about my background before I dive into my remarks. My copyright background includes largely working with artists and helping them protect their copyrights and litigating in particular. Our clients include Judy Chicago, Meow Wolf, the immersive art space, along with estates like the Arthur Conan Doyle estate, Sherlock Holmes. And so we represent a wide variety of clients. We're a small boutique firm that actually specializes in trials, based out of Santa Fe, New Mexico. And so it's exciting to be here and present on this. I'm going to start sharing my screen here in a moment, but I'll just say a few things. The first is that my presentation is geared towards artists, and so for the lawyers in the room, some of this may be things you already know about, but the idea is to give artists the tools and ways that they can help protect themselves in the new current landscape of copyright, particularly copyright in the digital age. As Carla mentioned, please put your comments in the chat, or comments or questions in the chat as we go. And Carla's been given carte blanche to interrupt me and let me know, and I'll try and create a dialogue. We're a small group, so don't be afraid if you have questions to ask them. Great. So let me go ahead and share my screen. And assume you can all see that. So today I want to talk a little bit about copyright in the digital age. And like I said, I want to give some tips and some information that I think every artist should know about. So the topics I'm going to cover today is why copyright registration is important, what the Digital Millennium Copyright Act is and how it's a tool that can help artists, and then the new small claims court that the Copyright Office has just started in the last couple of years. And we'll discuss all of those and hopefully give, with a goal in mind of giving the artists in the room tools that they can use and pursue and protect their copyrights, really without too much information from lawyers, and the reason I want to talk about that is because lawyers are expensive, and a reality for all artists, including some of the most successful artists in the world, is that they don't have millions of dollars to spend on attorneys. But there are a lot of great tools out there for you to protect your rights and to enforce your rights as an individual or in consultation with an attorney, but maybe not have them do the full-blown litigation. So start with why it's important to register your copyright promptly. So the Copyright Act gives you a few things. First, let me just say that when you create something, as soon as you fix your idea into a tangible medium, that's how the law describes it. So as soon as you take the idea that you have for a painting and actually paint it, or the idea that you have for a book and actually write it, as soon as it's fixed in an actual tangible item, you have a copyright. But registering your copyright with the Copyright Office gives you some important things. So first, without that registration, you can't actually sue anyone for that copyright registration. This is distinct from trademark law, where in trademark law, you can sue someone for injunctive relief, asking them to stop using a trademark, but you wouldn't be able to collect money damages without a registration. In copyright law, you're not allowed to sue at all unless you have a registration. And so it's critical. And the Copyright Act, in fact, encourages you to register your copyrights as soon as possible. You can, in fact, register a copyright for an unpublished work, so a work that you have not displayed publicly, and you can register it for a work that you've already published. But the idea is to do it as soon as possible. It's fairly low cost, and it's actually fairly user-friendly. To tell you the truth, when clients come and ask if we would do a copyright registration for them, most of the time what we say is, it's actually built for you to do it yourself. And the money that you're going to pay me is actually probably not worth it. We'll take a look at your application, but it really is a great resource for artists, and it's set up for normal non-lawyers to go and do the registration. And so it's something you should do. It doesn't cost a lot of money. And in fact, the Copyright Office will have a dialogue with you about parts of your application that they don't think are right, things that you can fix, and they'll actually engage in extensive emailing with you. They're really resourceful and really helpful. Whereas something like trademarks, generally you need an attorney, I think, to process trademarks as opposed to copyright. So copyright really is set up for the artist to drive the registration itself. So it gives you standing to sue, it gives you standing to enforce your copyright. Perhaps the biggest benefit under the Copyright Act, from a legal perspective, is that if you've registered your copyright promptly and you do file a lawsuit, you are the prevailing party is entitled to attorney's fees. Now, why is that important for you all? I can tell you that a very successful artist clients, who have one painting or one image that's infringed, and the damages may be $150,000, $200,000, which is a lot of money, but it's not enough money for most lawyers to get interested in the case. And so the prospect of being able to award attorney's fees helps not only your potential attorney get engaged and be interested in taking the case, but it actually ends up being the most significant piece of leverage against the other side in the case. I can't tell you, in fact, I just settled a case yesterday where the damages were $150,000, but the threat of $3 million of copyright attorney's fees at the end of it was what caused the whole case to settle before they even responded to our complaint. And so that is one of the biggest and greatest benefits of registering your copyright. If you don't register, you're not entitled to attorney's fees. So keep that in mind. The other thing about registration is that if the Copyright Act provides what I call on my slide a 3-month safe harbor for artists. And basically what that is once you've published your work, if you learn of someone infringing of your work, you have a 3-month window from knowing or should have known about that infringement to register your work and then get the protections that I just discussed under the Copyright Act. But let me tell you, it's better to avoid that 3-month window. There's a lot of debates about when you should have known, how you should have known, and just register your copyright as soon as you're ready to publish it, or as soon as you have fixed it in an actual tangible medium itself. The copyright, you can register items as groups. I have painter clients, for example, that will register 10 paintings together. Jewelry clients that will register multiple pieces of jewelry together. And so there's a ton of benefit to doing that process early so that later on you're in a really strong position if you need to enforce your rights. It works in practice. This case that just settled yesterday, the whole reason we had any of that leverage was because this client, even before they knew about us, had already gone out, gotten their copyright registration. They found it infringing work and came to us and said, look, I have a registration. We looked at the registration. We said, great, registration looks perfect. Let's figure out how we can prevent this company from using your artwork. And so it adds that extra oomph. Copyright I view it as a very moral thing. It's someone's creation, it's someone's art. But at the end of the day, the leverage of attorney's fees and being able to file a lawsuit is what actually prevents people from taking what is rightfully yours. So that's why registration is important. So one of the other things that you get as part of registration is the ability to use the Digital Millennium Copyright Act. So what is the Digital Millennium Copyright Act? The Digital Millennium Copyright Act is a part of the copyright statute that was frankly created to protect online service providers like eBay and Facebook and anyone that does anything on the internet from being sued. And what do I mean by that? We got to the point where the internet service providers or the online service providers went to Congress and said, hey, we've got all of this content on all of our websites and we shouldn't be liable for displaying it. And so you've got to protect us from having liability, for example, of on eBay for someone putting up a print of a work and saying that it's an original when it's not an original, or putting up a print of a work that's similar to a work that you own a copyright in and attributing it to you, even though it's not your work. So the online service provider said, we don't want to be liable for those things, and Congress kind of struck a compromise. And what the DMCA does, and I'll go into this in more detail as we get in, but it basically says, hey, online service providers are not liable unless they're placed on notice by the artists themselves that what they're displaying is infringing. And it requires those online service providers to create a way for the artist to basically easily place them on notice. And I'll show you some of those forms here in a second. That was the compromise to help artists transition into the digital age, right? You know, it used to be that we had paintings like the one behind me, and you know, the right to display it was limited to prints, and maybe you'd find it in a gallery somewhere. But now that everything's online, that's the problem that we're trying to solve. The DMCA also protects rights of attribution. So for example, like I said earlier, if the painting behind me was attributed to a different artist online somewhere, that would also be a proper use of the DMCA to prevent someone from saying, oh, that painting was done by Judy Chicago, when it's clearly not done by Judy Chicago. So those are the things that it protects. So how do you use the DMCA? The way you use the DMCA is through a notice and takedown system. That's the system that was created to be able to alert the online service providers like Facebook and eBay to that they are displaying infringing works. And maybe I'll just take a second and step back and talk about why display is important. The Copyright Act actually protects 6 rights, and the way our lawyers talk about these kind of rights is like as a bundle of sticks or a set of rights. And those 6 rights are the right to display your work, the right to create derivatives, so similar works, the same print but different colored ink, for example, the right to create and distribute that work, and a few other rights. And so the notice and takedown system allows you to assert those rights against the online service provider. So what does it look like? Here's Facebook's. They have a really nice form. They have one of the better DMCA forms. It allows you, so you'll see there's a several step process. You say that you're the rights owner, or you're reporting on behalf of a client like an attorney would, or you're reporting on behalf of someone else. I will tell you that the first 2 are, of course, are the best options. And the reason that is that at the end of a DMCA takedown notice, you have to affirm that you do actually own the copyright, and you do so under penalty of law. And so, so Facebook has a kind of click through item in their help center. eBay has a PDF form that you can fill out and submit via email. And this is their actual PDF form. And so I've got it here to kind of illustrate what information goes in there. You know, first, of course, is your name and title and all this information. You'll see the declaration, which I was just talking about, which says that you have a good faith belief that the person using the art or the image is not the lawful owner. And then the allegedly infringing material section. And the allegedly infringing material section is the most important section of this whole form. And in there, you want to make sure that you're putting your copyright registration number, because that is where they're going to look for your kind of clear statement of what your rights are here. And attaching your copyright registration certificate and providing them the registration number and the specimens that you submit to the Copyright Office is the most effective way to get items taken down. So Facebook, eBay, they get your notice of claimed infringement, and they're required within a certain period of time to immediately most of them immediately remove the work. There's a certain period of time where they have to remove it. And then they notify the person who, for example, posted the infringing print on eBay for sale that they've removed the work. And that person has the opportunity to protest and say, hey, no, I actually had the rights. And then you have an opportunity to respond to that. I will tell you, most of the time, people don't protest because they know that they're infringing, and they know that they're selling knockoffs. And so what it becomes is a very effective tool to kind of immediately addressing someone who's taking your works and infringing upon your rights in copyright. I will also tell you that if you own trademarks, although the DMCA doesn't apply to trademarks, DMCA takedown notices are also an effective way to assert your trademarks, generally speaking. You'll notice that this form from eBay doesn't say anything about copyright. It just says intellectual property owner. It says the intellectual property URL. And so most companies have generalized this kind of takedown process to all kinds of intellectual property rights, but including trademark. But the DMCA itself and the protections under it only applies to copyright. So that process is a process that you can do yourself. It is really simple. And it's, the most important thing is making sure that you identify what the infringing items are and what your copyright registrations in that application. And you're going to be in a place where it's immediately addressing the issue, because the online service provider, eBay, doesn't want to get sued under the Copyright Act. And they, generally speaking, err on the side of caution. I will also say that there are companies like Amazon who have a little bit more at stake to not removing items. So you can imagine that because they're taking a cut of the actual figurines that are being sold on Amazon, that they may not be as willing to take down certain items. But the key is to provide them with as much information as possible and to push back when they are saying that there isn't copyright infringement. And one way to do that is that the whole premise of whether someone is infringing your copyright is based on what is called the ordinary observer test. And the ordinary observer test says that an ordinary reasonable person looking at the two items, would they say that the other one is infringing the original or similar to the original? And you're an ordinary person. In fact, you're more than an ordinary person, you're an expert. And so you're even more qualified than the ordinary person to discuss whether this work infringes that work, and certainly whether a work infringes your work. And so you are actually extremely well situated to speak with authority about whether someone is infringing your work or not. There is no hyper-specific test that it has to be the same color or the same shape or the same font or the same. It's whether an ordinary observer would be confused, would think that they're similar. For example, a ring or a jewelry design that has different colored stones or different types of stones, turquoise versus opal, those may still be infringing, even though they have some differences, right? Some differences in color. So keep that in mind. If you are looking at a work online and go, that really looks like my work, that someone is going to think that that was my work, then you're in a position to say with authority that there is infringement taking place. So the thing that I'm most excited to talk about, because I think this is the one of the coolest things, is the brand new copyright small claims court. And when I say brand new, I mean kind of brand new under the law. It's been around for a couple of years, but not a lot of people know about it, and not a lot of people are utilizing it. So I want to give you some information about it, and I think it's a great tool for artists to use. And so what is the Copyright Claims Board? It's similar to small claims court. And so what do I mean by that? Most courts around the country, state courts around the country, have a court where regular people can go without a lawyer and assert their rights to, they got bit by a dog, or someone's built a wall on their property that they're not supposed to have built, or, you know, these items that the damages are small, but it's important to that person. And those are small claims courts. And I am a great fan of small claims courts. I think they are the place where people really are there because they believe in what the issue is. And they're not just in it for the money, or they really believe that they've been wronged in some way. And I'm a big believer in access to courts without attorneys. And so the copyright board created the Copyright Office created a board that deals with copyright infringement claims limited to damages of $30,000 and below. And what that does is it opens up a whole world for pro se people not represented by a lawyer to bring their claims for copyright infringement. I'm going to tell you a couple of ways in which it facilitates that. The first, you know, so you'll see from my slide, the proceedings are entirely electronic. There is no going to a building. There's no flying to Washington, D.C., where the Copyright Office is. Everything is entirely electronic and submitted on the papers and over Zoom, just like this. So anyone, anywhere in the world can file a copyright claims if they have a copyright registration in the United States. So this court has existed for about 5 years now under an act of Congress, but only 1,250 claims have been filed. 65% of those claims, though, are pro se, are people without lawyers. And so what this does is they create a 3-person tribunal that looks at your claims, looks at what you filed, and holds a hearing on whether there's infringement or not. What's also really great about this program is that there's a Copyright Claims Board handbook. And that handbook explains for the layperson in detail everything that you need to know about how this proceeding works, how you file your claims, what you need to present, every possible detail. I was amazed at all the details that are in there, and I encourage you to take a look at it. You can find it simply just by Googling Copyright Claims Board handbook. But it's providing for the first time an avenue for artists without lawyers to vindicate infringement and to pursue and protect their works in a way that makes sense. And by contrast, before this act, all claims had to be brought in federal court, which is the most formal of the court systems. Not a lot, you know, some attorneys practice in it, some don't. And it was a much more restricted process. And so if you think someone's infringing your works and you told them to stop and they continue to keep going, the Copyright Claims Board is an awesome option. And it's something that an attorney can help you with a little bit, and you can do it yourself, or something you can do yourself and if you're paying attention to the Copyright Claims Board handbook. So really encourage you to do that. I think it's probably one of the most powerful tools that artists have in their quiver to assert. So I know we're running close to my time here, or at my time, but so just want to give you some takeaways. The biggest takeaway is register your copyrights early and often. The amount of rights that you get and the ability to defend your property goes up exponentially when you do the registration. The second is, I want to encourage you all to enforce your rights. and to use the DMCA and to go to small claims court, because protecting your work is in my mind, the essence of saying you own this painting, you own this design, you own this this trademark, in terms of other kinds of IP. And that is, if you don't do that, from a practical standpoint, the value of your art goes down, those sorts of things. But it just seems to me like you created this, you're the artist, you should be empowered to say, I created this and I own the rights in this. And someone else isn't allowed to go and copy that and gain, financially off of it. And so I want you to do that. I want to encourage you to do that. With that, I'll say thank you. And say, if you have any questions, please ask them. I'm all ears, happy to help. I will say I'm not licensed in New York, so I can't give you advice about New York law, but we can talk about copyright.
Thank you, Billy. While we wait for any questions in the chat, I would like to ask you, your presentation focuses on enforcement. I'm thinking, is there anything in the preventive side that artists can do if maybe they want to post their works online to show their portfolio, to advertise? Would a copyright notice be enough? What do you say that you find useful?
That's a great question. I think copyright notice, I think I have a tendency to focus on enforcement because I'm a litigator, but the copyright notices are useful, but you don't need to have them in order to assert your copyrights. I think they're preventative. I think an invitation to, if someone wants to use your work, and someone wants to, say like an offer to license your work or something like that could be helpful. Encouraging people to talk to you and create a venue in which open that dialogue and contact you is really useful. But I do think people who infringe, in my experience, tend to know that they're infringing and tend to do so maybe without understanding the implications of it, but know that they're copying someone's work fundamentally. And so placing them on as much notice as possible, I think, is always great.
Thank you. We have a question from Lynn asking, how does it work with LLMs taking one's book to train their AI models?
It's a great question. So the large language model problem is being litigated all over the country right now. San Francisco, New York. And so I can offer, the law moves very slowly in relationship to technology, but I can offer some thoughts I have on it. The question is not so much about whether taking the content of your book and storing it in a server somewhere is a violation of copyright. That's probably not a violation of copyright. Where it becomes a violation of copyright is when they take your book and they turn it into another book, or someone generates something using ChatGPT based on that large server, large language model storage. And that's the moment where there's a derivative work created, or they are now distributing your work in some way. And so in terms of using, for example, the DMCA to enforce your rights against OpenAI or ChatGPT, if you know that they have scraped your book off the internet, which I suspect they have, then you could assert potentially use DMCA to say, don't stop generating content based on my book. Whether that would be effective or not right now, given that it's such an early stage of the law, I think is an interesting issue. I will say recently the Copyright Office rejected a visual piece that was wholly generated by AI saying that the United States Constitution specifically uses the word person. And for those of you who don't know, copyright is in the Constitution. It's a constitutional provision. A lot of people don't know that, but saying that the constitutional provision that creates copyrights uses the word person, and so you can't, an AI generated art is not available for copyright protection, and that's recently been upheld by the next appellate level. And so and it sounds like there's also some resources in the handout that the Art Center puts on. So those are probably good as well.
Thank you so much, Bailey. I don't see further questions, and this is good because we are at time. Thank you so much. Thank you for all the participants. If you have only an introductory remarks ticket, this concludes this portion of the program, and feel free to disconnect. If you have a consultation ticket, please stay on the call. We will be opening the breakout rooms and assigning, and you will be seeing a message prompting you to join the room. Just as a note, Nate and Morgan, I don't see your clients in the room just yet. I will assign you to the rooms, and once they show up, I will send them your way. Okay, perfect. I will stop recording. Thank you so much, everyone, Billy in particular, and our volunteers for their time as well. I hope you enjoy your evening. Have a good day.